RA 7877, Anti-Sexual Harassment Act.
Republic Act 7877, Anti-Sexual Harassment Act. Republic Act number 7877, otherwise known as the Anti-Sexual Harassment Act of 1995, is enacted primarily to protect and respect the dignity of workers, employees, and applicants for employment, as well as students in educational institutions or training centers. It likewise provides for the duties and liabilities of the employer in cases of sexual harassment and sets penalties for violations of its provisions. It is to be noted that a victim of sexual harassment is not barred from filing a separate and independent action for damages and other relief aside from filing the charge for sexual harassment.
This act shall be known as the Anti-Sexual Harassment Act of 1995. The state shall value the dignity of every individual, enhance the development of its human resources, guarantee full respect for human rights, and uphold the dignity of work, employees, applicants for employment, students for those ongoing training, instruction, or education. Towards this end, all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful. Work, education, or training-related sexual harassment is committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person who having authority, influence, or moral ascendancy over another in a work or training or education environment, demands, requests, or otherwise requires any sexual favor from the other. It shall be the duty of the employer or the head of the work-related educational or training environment. The employer or head of office, educational, or training institution shall be solidarily liable for damages arising from the acts of sexual harassment committed in the employment, education, or training environment. Nothing in this act shall preclude the victim of work, education, or training-related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. Any person who violates the provision of this act shall upon conviction be penalized by imprisonment of not less than 1 month nor more than 6 months, or a fine of not less than 10,000 pesos nor more than 2,000 pesos, or both such an imprisonment at the discretion of the court. If any portion or provision of this act is declared void or unconstitutional, the remaining portions or provisions hereof shall not be affected by such declaration. All the laws, decrees, orders, rules, and regulations, other issuances, or parts thereof inconsistent with the provisions of this act are hereby repealed or modified accordingly. This act shall take effect 15 days after its complete publication in at least 2 national newspapers of general circulation.
Republic Act 7877 mandates that the employer or the head of the work-related, educational, or training environment or institution duties in ensuring the enforcement of this act. They must provide the procedures for the resolution, settlement, or prosecution of acts of sexual harassment. Republic Act 7877, an act declaring sexual harassment unlawful in the employment, education, or training environment and for other purposes, was approved on February 14, 1995, and became effective on March 5, 1995, 15 days after its publication in the Malaya and Times Journal on February 8, 1995.